SJC-13789, Commonwealth versus Jermaine Berry.
Okay, Attorney Caddick.
May it please the court, Elizabeth Caddick for Jermaine Berry. We are here because Mr. Berry requested his constitutionally required Perez hearing after having committed a crime as a 20-year-old and sentenced to consecutive sentences totaling parole eligibility 16 years longer than had he been convicted of murder.
Can I ask you, you filed your motion pursuant to Rule 30, correct?
Yes.
Why isn't this Rule 30 discovery, which allows a judge, which allows any party to move for post-conviction discovery?
Well, it's simple. It's not a motion for a new trial where you would need additional evidence, where you're submitting additional evidence.
Well,
this is merely a 30.
But could you answer my question?
Yeah.
Procedurally, right? If you file under Rule 30, doesn't the Commonwealth have a right under Rule 30 to post-conviction discovery?
For a resentencing hearing, well, actually, I did not research that. I know that a defendant is entitled to.
It's both sides.
Discovery.
It says any party.
Right. Okay.
I think it's Rule 30C.
Okay. But the discovery, simple discovery, is different than what is ordered here, which is a compelled psychiatric examination. There has to be a rule, a statute, or a SJC decision that mandates that someone undergo an examination by a Commonwealth expert that would violate his right against compelled self-incrimination or violate his right to privacy.
Wouldn't the judge have the discretion under Rule 30C to say, I'm going to grant you discovery and I'm going to use Blaisdell and the Rule 14 procedures for said discovery?
No, because a compelled self-examination is not the same as asking for evidence, statements of witnesses. This is a particular area that only allows a compelled psych examination when a defendant raises a mental health defense to counteract the mens rea charge at trial, or as the court has expanded Rule 14, it's during the same proceeding, the defendant raises his mental health as a way to mitigate sentencing, saying, well, he shouldn't be punished because he was mentally ill and didn't understand what he was doing, or if it has to do with competency to stand trial, or the only other instance.
Can you expand on self-incrimination for a moment?
Yeah.
Typically in a pretrial situation under Blaisdell and Rule 14, the self-incrimination are statements that would incriminate you for the crime that you're charged with, correct?
Right.
Here, it's post-conviction.
Right.
Isn't there a different self-incrimination component to it than in a post-conviction structure?
I would say no, because the cases that have looked at the right against compelled self-incrimination with psych examinations stated not only that the person being interviewed by the Commonwealth's expert could speak to what he did during the crime, but it could open him up to charges unrelated to that, for new charges unrelated to that crime. So I would say that case law applies to this situation.
No statute of limitations?
There is no statute of limitations, but there's no purpose. I mean, there's got to be a purpose. The court cannot violate your constitutional rights without there being jurisdiction and power by the Superior Court to do that, and the Superior Court does not have that. You can't use a rule that's for a pre-trial procedure and apply it to something where the person is just asking for his constitutional right to a resentencing hearing, where all that is to be considered at this resentencing hearing is to put into context his upbringing, his perhaps adverse childhood events, his actions and mental state at the time of the crime, and his rehabilitation afterwards. Looking at
sorry,
his,
counsel, the problem for you and for the argument is that your client is actually proposing himself to put in a psych evaluation of his current mental state. I realize that the record may have shifted, but what was before the single justice was that you were putting in a psych eval about his current mental state and rehabilitation. And usually the scope of a waiver of the right against self-incrimination is determined by what the defendant chooses to say. So what's your best argument that the putting in that information from the psych eval that you want to put in does not create a waiver for the scope of what you've put in?
all he put in was an aid in sentencing. It was entitled an aid in sentencing. It's what defendants put in all the time when they're sentenced. It's what they put in when they are before the parole board and they're Perez and Matt.
So the label governs whatever you decide to call it?
No, but he didn't put it in to say, I'm mentally healthy now. He put it in to do what Diachenko too said to do, which is to have the expert explain his upbringing, how that affected the crime, and his post-sentencing behavior and his risk for reoffending. And that is exactly what Dr. Galvin did. She didn't put it in to say, oh, he's mentally healthy. It's all part of what an expert does in order to determine that their risk is low.
In your view, what can the government do when faced with the kind of showing that you put here, which includes post-conviction information?
I think that the government has been able to handle these Perez hearings and these Miller hearings and these Costa hearings without compelled psych examinations before. What the court in Perez 1 and Perez 2 said is look at the behavior post-sentencing.
Were in those cases, did they involve a situation where mental health or mental capacity were at issue during the trial?
Well, I have not examined all of I haven't researched all of it.
Wouldn't that seem to make a difference? I mean, it seems to me that part of what you're hearing from the bench, and I don't want to speak for anyone else, is the tension that's created by, on the one hand, claiming that the inquiry at this stage is retrospective. You're looking at these factors that would bear on the defendant at the time of the conviction, but then trying to put in information about his rehabilitation and mental health thereafter, while not allowing the Commonwealth to test that post-conviction information.
Okay, two answers. One is Perez had raised a mental health defense at his trial. In fact, he raised it as that his uncle had compelled him to do this. At sentencing, the Commonwealth didn't ask to have a psychiatrist now evaluate him to see if he had that. The other thing is the psychiatrist who evaluated Mr. Berry at the time of his trial found he had no mental health issues. And also, I believe what the court did in this case is misunderstood what the Mattis factors were. The Mattis factors and the Diachenko factors looked at what someone's brain was like as a juvenile or an emerging adult, and how they didn't have impulse control, how the trauma that they're raised in affects their ability to function in society, and that they mature out of that. And so by saying someone has matured out of the fears and paranoia after living in a dangerous environment where people are dying, including own family members, or shot on the front porch dead, that trauma that he was experiencing as an emerging adult has changed and he's matured. This court never asked for a psych evaluation for someone before they had a Miller hearing.
Is someone's mental health or ability to function relevant to the inquiry on the defendant's individual characteristics? Is that at play in a Perez-Miller issue?
Yeah. Yes, it would be, because what you're, yes,
Okay.
because that's what the court looked for.
So if that's the case, how is this not violative of all our case law on one-sided presentations of expert witness?
Well, I would say it's because I have never found a case that said when a defendant says he doesn't have a mental illness, that gives the Commonwealth the power of a compelled psych exam.
At trial, the same expert said your client was schizophrenic, correct?
Was what?
Schizophrenic.
No, she did not say he was schizophrenic. What she said was he has schizophrenic characteristics based on his upbringing, and it wasn't a
That was at trial?
Yes. Yeah, her report and her testimony at trial. And so it's a spectrum, and it wasn't a definitive diagnosis he has schizophrenia. It was that some characteristics. He has a paranoia, which is characteristic of schizophrenia, but she explained it in light of all of his childhood upbringing, being raised by crack addicts in a very dangerous
It was a diminished capacity type defense.
That's what it was, right? That the police who burst into his bedroom, because he was primed to be fearful of everything, he shot at them, but not with an intent to murder them. Or that was the defense.
Counsel, quick question on the testimonial components of this. So that's part of what you're focused on, but the Commonwealth hasn't gotten any evidence yet. And so with this compelled psychiatric evaluation, how is that meaningfully different than when we tell defendants you've got to give fingerprints or you've got to give DNA in buccal swabs? How is this any different than that?
When you said the Commonwealth didn't have or evidence?
They haven't had the examination yet.
Right.
So we're talking in the abstract. So in the abstract, how is this different than when we compel defendants to give over fingerprints, or we compel them to give over DNA in saliva swabs?
Well, I would say that fingerprints and DNA are very different, and this court has even said they're very different than a compelled psych examination. And there is a purpose for fingerprints and DNA. It could lead to evidence that the defendant committed the crime. In this case, what the sentencing court will have and what the Commonwealth has is objective evidence that Mr. Berry is rehabilitated. His time in prison, it has his programming, his responsible job.
Objective based on whose perspective? Yours?
No, on the objective evidence of the Department of Corrections records, which is what this court asked for in Costa, which is his post-sentencing behavior presented by either the Commonwealth or the defense.
But counsel, the issue is that that's not all that you're trying to rely on. That the issue is whether there's a waiver of the defendant's right against compelled self-incrimination because you're putting in more than the DOC records. I don't think that the Commonwealth, I think, is making an argument that regardless whether you're putting in your exam, they should be able to do this on the basis of the waiver at trial. But putting that to one side, you're not just relying on the DOC records, which could not possibly amount to a waiver.
No, it's not a waiver. And in fact, it's something that the Commonwealth gets itself. But when someone waives their right to compelled self-incrimination or right to privacy at the trial level by raising a criminal defense, insanity defense, a criminal responsibility defense. They do that knowing that they are waiving it if they actually present evidence. This court has never said that someone saying they are not mentally ill waives their right against compelled self-incrimination by a Commonwealth's expert. This court has never held that, and yet that's really what it is exactly what the Superior Court did. She said that this is what the statutes, this is what the Rule 14 says. If you're raising a mental health defense at trial, and you put your mental health at the time of the crime at issue, the Commonwealth has the ability to have their own psychiatrist examine you. That's all it says. No case, no rule, no statute has ever said that simply saying you don't have a mental illness, you're waiving your right to a compelled psych exam. And if this court is going to say that if you submit an aid in sentencing, which I argue always has the overview of a mental health exam, not a deep one, but they do the risk, and even the Superior Court described in her decision, which the single justice in this court has, is what Dr. Galvin said, and she just looked at what his risk was using these factors and found it was low, and that he doesn't have mental health issues. And so if it's going to now, after all these years, say that simply adding an aid in sentencing report that says you don't have any mental health issues means you're waiving your right to compelled self-incrimination, I think that's quite a momentous decision. What Mr. Berry had done is, in order to move along his Perez hearing, had said in court back in the spring that he would waive his right to submit Dr. Galvin's report and just go straight to the hearing, and won't say that he doesn't have any mental health issues, and won't say that he's rehabilitated, because that was another reason the court gave for a compelled psych exam, saying he's rehabilitated. That means he's put his mental state at issue. He should have a compelled psych exam. And then the Commonwealth came back and said, well, we still want a compelled psych exam, even if he isn't putting his mental health at issue, because we have the burden. And the judge agreed with him. It would make new momentous law to say that simply saying you don't have a mental health diagnosis, and this would apply to anyone in pre-trial also, if that's what the case is. Again, there's no basis, and if this court would rule that, it would be creating a power that the superior courts don't have now.
Okay, thank you. Attorney Martino.
Good morning, Your Honors. May it please the court. Elizabeth Martino on behalf of the Commonwealth. And I apologize, I've lost my voice, but I'll try to keep up so you can hear. The Commonwealth is asking that the court affirm the single justice's order finding that the motion judge did not abuse her discretion in allowing the Commonwealth's motion for a psychiatric evaluation of the defendant.
Is this Rule 14 or Rule 30 discovery?
I think we analogize to Rule 14 in the motion, but it would be, I think, Rule 30 discovery.
All right, so, but you moved pursuant to Rule 14. That was a mistake, correct?
Yes.
Was that a mistake?
I think we were analogizing, and I
Oh,
think
you said it was pursuant to Rule 14.
yeah, and
That was a mistake, right?
yes, it should have been under Rule 30, Your Honor.
All right, so what's the fallout of that mistake?
Well, I think that the judge understood that it was similar to pretrial in the fairness doctrine of if the defendant introduces an expert that relies on the defendant's own statements that the government has the ability to rebut with their own expert. And that's the doctrine that I cite in my brief that's been expanded since Blaisdell. And most recently, I think in Commonwealth versus Connors, which is a 2006 case cited in my brief with the SDP hearings.
So if we analogize this to Rule 14, and the defendant, as it happened later on in this case, never presents expert testimony, doesn't, under Rule 14, doesn't your right to have someone examined, even though you bear the burden, go away?
Well, I think once the defendant notices his intent to rely, then we have the ability to get our own expert, and we may not be able to introduce the evidence if that intent never comes to fruition, but we still have the ability to, have our expert be able to rebut, so that if the defendant does rely at trial on a mitigation, diminished capacity defense, then we are ready to rebut it. And here, the defendant had indicated that he was going to introduce this aid in sentencing report.
I think it's a marked difference when the defendant did in fact file this document, right, versus not filing it. So if someone notices their intent, right, and then they don't go forward with it, they withdraw it, you can't have the person examined, correct?
Well, so for example, in the trial of this defendant, right, he noticed his intent to rely, got an expert, we got an expert. We didn't end up using our expert at trial because we proceeded through cross-examination, but we had the expert report that was sealed that we could have used,
It was never released to the...
Right,
okay.
Right, but I think it's a little bit similar here, and also because this was sort of a Rule 30 motion, it hasn't been tracked the same way as a pretrial, hearings. Everything hasn't gone exactly. So I think the aid in sentencing report was perhaps not filed, but it was attached to the Rule 30 motion so that the court had it.
The protections under Rule 14 in Blaisdell for self-incrimination and who gets what expert testimony and when, that should follow suit under this scheme?
I think it should be analogous, such that when the defendant notices his intent to rely on an expert to whom he's given statements, then we can file a motion under Rule 30 properly next time for our own expert so that the fairness doctrine is met, that the defendant isn't able to just produce a one-sided report with his own self-serving statements without any rebuttal from the government. So that's really the Commonwealth's position. And here, it doesn't have to be a categorical decision because the facts here, I think, support the Commonwealth's argument in this fairness doctrine.
Why wouldn't discovery from the defendant's expert be the first step?
So the aid in sentencing report explained the things that Dr. Galvin relied on, including multiple in-person and phone interviews, 9 hours, I believe, and interviews with family members and people in the Department of Corrections, as well as documentary evidence. So the government had all of that. The Commonwealth had all of that from the defendant, as well as our own, Department of Corrections reports, which then we retained an expert. We let the court know we were retaining an expert to review the same documentary evidence. But obviously we didn't have, the interviews with the defendant or anything, but Dr. Galvin's reports from trial, Dr. Galvin's reports from 2025, and then all the supporting documentation that she had.
And did you make an argument that was insufficient?
I did, and that's in a transcript.
Why was it insufficient?
So in speaking with our retained expert, his concern was the legal standard was to show extraordinary circumstances of the crime and of the individual, such that there's no reasonable possibility of reform and redemption within the 15-year presumptive parole eligibility. And there's lots of factors to consider. Part of what his concern was the several mental health issues that were relied on by the defendant at trial as part of his diminished capacity mitigation defense, and then a complete dearth of any mental health treatment. his concern to me, which I brought up to the court and which is in the record in the transcript, was that operating without any disciplinary reports for a recent period of time may indicate an ability to operate within a controlled environment, but not necessarily rehabilitation. And so he asked if he was able to examine the defendant to get a better ultimate conclusion on the extraordinary circumstances. And so I filed a motion with the court to do that.
What I'm concerned about here is conflating the parole eligibility determination with the parole determination itself.
Yes, Your Honor.
Can you talk about maybe why I shouldn't be worried about that?
Yes, Your Honor. And I think, and I wanted to mention that when we were talking about, my sister was talking about, well, an aid in sentencing report is normal under Dychenko, but there is a difference between sentence and meaningful opportunity for parole and the considerations for the parole board. There's a constitutional right of the defendant to have a resentencing hearing here because we agree that the sentence was presumptively unconstitutional, but then the Commonwealth, under this line of cases, has the ability to show the extraordinary circumstances and the parole eligibility constitutionally should be later, based on the factors laid out in Miller, Perez, and Costa. So that is one consideration, the sentencing. And then the other is parole eligibility, which is a parole board, executive, Dychenko, those things.
Right. So what would be the Commonwealth's ability to get a psychiatric examination, if there is one, at the point of the parole determination?
I don't know. I don't actually know the answer to that question. So with Dychenko and all of those cases about the due process rights for expert funds and experts at a hearing before the parole board doesn't actually implicate the government because it's a separate proceeding. So it's not adversarial. This is about sentencing. And what's difficult, I think, and I'm trying to not overspeak, but there's so many years that have passed since the original sentencing. And so these cases are a little bit difficult because in the normal course and going forward, the government has the burden at sentencing after a trial to show that this, juvenile or emerging adult is uniquely faced with extraordinary circumstances, both as to their crime and the individual. And so at trial, if the mental health defense was live and we had our own expert, rebutting the defense, all of this would be fleshed out before the sentencing judge.
The parole, the determination of parole still involves the government, it's just a different branch of the executive, correct?
Yes, Your Honor.
Subject to its own rules and regulations
Yes, Your Honor.
that you're not part of.
Yes, Your Honor. So I don't actually know the rules about what kind of rebuttal experts we have, but I think it's more collaborative, for lack of a better word, at the parole hearings in terms of, this is adversarial. This is, we have to meet a burden to show that we believe that the defendant deserves the longer parole eligibility. And that's why we're going forward. And that's why I talk to an expert about the implications of what the defendant raised in the aid and sentencing report and how that affects my legal burden of showing extraordinary circumstances as to the crime and extraordinary circumstances as to the individual. And we know from this court's decision in Costa that in addition to the Miller factors and the regular sentencing factors, when it's years later at a resentencing hearing and at an evidentiary Perez hearing, the resentencing judge considers post-sentencing conduct, favorable and unfavorable. And that includes psychological treatment, that's germane to rehabilitation.
So in light of,
I'm sorry. Attorney Martino, what concerns me about what you're saying is about 5 minutes ago, you said that this doesn't have to be a categorical approach. But I don't understand how that can be. Because specifically, one of the Perez Costa factors, and I'm speaking about number 4, the defendant's chronological age and its hallmark features, including immaturity, impetuosity, and failure to appreciate risks and consequences. Now, if you're a defendant and you're in this cohort, and you want to be resentenced, and you think that you have a right to be resentenced because you've grown, you've matured, you've gone through programming, you've gone through therapy, you've gone through all these different things while you've been in the custodial environment. And how does that not quell a defendant saying, I'm not even going to put anything forward because if I do, that the Commonwealth's going to say, I have a burden, particularly under Factor 4, and I want to compel you to subject yourself to a court-ordered psychiatric evaluation. Doesn't that, in effect, turn this categorical?
I would disagree, Your Honor. I think actually, again, it's a little bit hard to evaluate because we're so many years later. And in this case, the defendant is saying, I am rehabilitated, and here's my expert who says that based on my interviews.
Right.
With the.
That's my point. Aren't they all going to say that?
But there's a body of law, a body of social science studies that came out in Dachenko, Mattis, and all of these evidentiary hearings that I don't think need to be replicated and litigated in each case. It's sort of accepted as fact now that people 20 and under have problems with.
But the problem with that is these are individualized resentencing hearings.
Yes.
Right? So to the extent that it's individualized, the defendant's got to show that this is particular to
They
him
can do
or her.
that without having an expert to whom they give statements on which they rely, right? That's the sort of dispositive thing here, and that's the fairness doctrine. So a defendant, hypothetically, could say, I'm going to have an expert talk about hot and cold cognition, impetuosity, all of the hallmarks of youth and emerging adults that are applicable to my case without giving an interview to that doctor about the specific facts of his case that are perhaps self-serving, right? The fairness doctrine says, and so that the hypothetical situation, the defendant could do a hearing, use all of the body of, expertise.
To argue to the judge to draw the inference.
Yes.
And is, in your view, drawing an inference like that is part of an individualized assessment?
Yes, and I think in that case where he doesn't necessarily give a personal interview where he's relying on his own statements, he's just using the body of studies and saying it's applicable to my case, that's very different and doesn't necessarily, under the fairness doctrine, empower the Commonwealth to move.
Does that go to the discretionary part of Rule 30, where it says that a judge may authorize such discovery if in fact a separate psychiatric examination is involved?
Yes, and yes, Your Honor, thank you. And I would like to draw the court's attention to the Connors case that I mentioned earlier, 447 Mass 313. At page 317, this court said in the STP analysis that whereas a statute, even though the statute didn't explicitly state whether allegedly sexually dangerous people may offer his or own expert testimony while refusing to allow court-appointed qualified examiners to conduct their own examinations, we conclude that permitting the defendant to offer his own expert testimony based on personal interviews while refusing to submit to interviews with court-appointed experts offends basic notions of fairness. So there was no particular statute that authorized it, but this court said, look, you can't have your own interviews with your own expert, with your own self-serving statements with that conclusion, and then not allow the government who carries the burden here in Perez hearings to be able to have their own expert evaluate the defendant. It's just a fairness doctrine. It's gone through, and I cite in my brief since Blaisdell all the different ways that this court has expanded it. And of course, scope is limited. And of course, there's the fairness is not only about our opportunity to have our own expert interview the defendant.
So what would be your rule? Because this sounds a little bit different to me than the construct you were proposing in your brief. I understood your brief to propose in any case where the defendant had put his mental capacity or mental health at issue during the trial and then later claimed rehabilitation, that the Commonwealth would be permitted to conduct its own psychological evaluation. Is it now that not just claiming rehabilitation, but putting in his own expert to support that contention would entitle the Commonwealth to its own examination?
Well, yes, Your Honor, and I actually think those are the same, because if a defendant relies on a mental health mitigation defense at trial, he's going to have had an expert to whom he
Maybe he could just rely on his DOC records. He could just show this unblemished, period of incarceration.
I think, but if I'm understanding the question correctly, that's a different scenario than the one you originally
That's why I'm
posited.
trying to understand
Yes.
what the legal principle is
Yes,
that the Commonwealth is proposing that we adopt.
yes,
It's the defendant put his mental health into play, or mental capacity in play during trial. Later, at the Perez-Miller stage, puts his rehabilitation into, asserts rehabilitation and supports that assertion with psychological evaluation. In those circumstances, the Commonwealth would be entitled to its own examination. Is that the principle that you're?
yes, Your Honor, and also even a bit further, even if there was not necessarily the aid in sentencing and the new expert, the additional 2025 expert, I think the Commonwealth would be able to move for its own expert, where at trial, the defendant relied on an expert to whom he gave statements and interviews.
Wouldn't the scope, though, be limited to the scope of the statements at trial? As you acknowledged, there's many years of history between now and then. There are disciplinary reports. There are things that occurred potentially that could even be criminal conduct. So wouldn't the waiver have to be limited to the scope of what the defendant's statements were at the time of trial?
Yes, Your Honor, and that would be fleshed out, I think, at in each particular case. And again, this shouldn't be happening. As I think going forward, these hearings where the government carries the burden to show the longer parole eligibility should be happening at trial, right? So now that we know the law, so we'll finish with these cases where people were sentenced years ago, and this is difficult, but I think manageable with these doctrines in mind. The fairness doctrine, limited scope, and making sure to keep everything to the factors that this court has laid out that are germane to these Perez evidentiary hearings and resentencing.
So in this case, now that the defendant knows that the Commonwealth was, wanted its own expert, what is it that the defendant can do to minimize the defendant's exposure?
Well, again, our expert, if the court finds is entitled to interview the defendant says what he wants to say. I mean, it's compelled by the court such that our expert is allowed to go to the prison and talk to him, but he's not compelled to say anything. Certainly, always.
All right.
The court has no other questions. Commonwealth rest. Thank you, Your Honors.